This is Dr. David Schein, and welcome to Business Law 101. Now, strict liability is, as I mentioned, is kind of the bane of producers and people selling things, because if you make something, you can be held strictly liable. And a couple of the examples, of course, are Bayer Chemical bought Monsanto. Monsanto, one of their big sellers is Roundup. And of course, there are plaintiffs out there claiming that Monsanto Roundup causes significant cancers. So that's been a big running dispute about whether they're strictly liable for having made this chemical. Another case that's very active today is Johnson baby powder, and saying that it has trace amounts of asbestos in it, and because of that, it may have led to certain female cancers. And so that's another example of strict liability. You made it, you should have known better, and people have got cancer, and that's your tough luck as a business. Now, one of the interesting doctrines is another word I want you to be familiar with is privity. Now, if you have a regular word processing program on your computer and you put in privity, it'll most likely underscore as spelled wrong, even if it's spelled right, because this is a very unique legal term. So the role of privity is a situation where it means you're in direct contract. So, for instance, you purchase a brand new Honda lawnmower for $600. You're using it, and it shoots out a rock and hits your kid who's standing in the yard while you're cutting the grass, and the kid gets a whack in the head and is at the hospital and all that jazz. And so the issue becomes, well, the kid who got hit didn't buy the lawnmower. He didn't have a contract with Honda. He didn't have a contract with the business that sold the lawnmower. Then how can his injury be the responsibility? Well, it's because over the years, the doctrine of privity of contract for tort liability has largely been removed. So, for instance, the same Honda lawnmower, you buy it from your neighbor, so you're not the direct buyer anymore, and you're using this 6 or 7 year old Honda lawnmower, and it causes some injury or something like that. You can sue Honda for defective design or defective manufacturing. We're going to talk some more about that in a second, but you do not have to have privity, meaning a direct purchase from Honda or Honda distributor. I want to just mention quickly the concept of the role of the restatement. We mentioned in our first class that the United States follows the British tradition of something called the common law or case law. Well, what happens after a few hundred years, the case law becomes pretty scuzzy and unclear. And so what happens is a bunch of academics and practicing attorneys get together, and they work in groups to summarize the case law up to a certain point. And so we talk about restatement second of torts, helps to lay groundwork that gives each state some guidance in preparing their state laws regarding the way things should be interpreted. Also, if there's not a statute, sometimes the restatement is a reference point for judges to make legal decisions. So some of the things we're looking at under Section 402 of the Restatement Second of Torts is, do we have a defective product that's unreasonably dangerous because of the defect, that the owner of it, the purchaser, has not modified the product, or it wasn't modified after the factory, and that there's a damage suffered using the product. And again, using my Honda lawnmower example, is one of the things that people commonly do is a safety feature on most modern lawnmowers is there's two handles. And in order for the lawnmower to keep running, you have to press the two handles together. The idea being is it keeps you behind and away from the lawnmower, and you can't go around it while it's running and get your foot or your hand hurt. So, of course, what do most of us do with the two-handle lawnmower? Well, we tie the two pieces together with a piece of wire or string, or perhaps a piece of a coat hanger, so that we're not inconvenienced by that if we need to move some chairs in our yard or something like that while we're cutting the grass. So that would be a modification of the product that may or may not lead to the injury of someone involved in it. And then there's damage suffered using the product, of course. Now, one of the troublesome parts about this is it's not just the manufacturer. So the Honda lawnmower may have a Briggs & Stratton engine. Briggs & Stratton's responsible. Honda's responsible. The product distributor is responsible. It's sold at your local lawnmower retail store, outdoor specialty store, and they also have responsibility. So everybody gets sued, and of course it makes products more and more expensive as we have to continually insure up the scale. Regarding torts, we looked at the restatement second a few slides ago. Note we're up to the restatement third of torts. And so some of the areas that we look at with regard to product liability are manufacturing defects, design defects, and failure to properly warn people.